There's a distinction between the word winding up and the dissolution. Winding up follows dissolution. Dissolution do not follow winding up. Please remember that. Okay? Winding up is a fourth stage in the process whereby assets are realized, liabilities are paid off, and surplus, if any, distributed among its members. Dissolution is the final stage whereby existence of company is withdrawn by law. Liquidator appointed by company or court carries out the winding up proceedings, but order for dissolution can be passed by court only. Remember that. According to Companies Act, liquidator can represent the company in the process of winding up. This can be done till order of resolution is passed by the court. Once court passes dissolution order, liquidator can no longer represent the company. Creditors can prove their debts in the winding up, but they cannot prove the debts on the dissolution. Remember, winding up in all cases does not culminate in dissolution. Please remember, even after winding up, company can earn profits and company can revive itself. But dissolution means end of the company's existence. Second point, there is a winding up proceedings, but order for dissolution can be passed. Correct. Creditors can prove their debt when the company is in the winding up stage. But once the company is dissolved, creditor cannot prove their debt. Understood? Because company has already gone through the process of winding up. Over there they have to claim and not at this stage of the dissolution. Clear with this? Creditors will be given opportunity, but that stage is called as a winding up and not the dissolution. First we'll see winding up by the court. Now why will court order the winding up? It is purely the jurisdiction of High Court to entertain the winding up order under 1950. Now why will court order winding up? Section 433 of 1956 may be wound up by the court if company has passed a special resolution of its being wound up by court, a default is made in delivering statutory report to ROC or holding the statutory meeting. This is not applicable to us now. It does not commence business within 1 year from its incorporation or suspends the business for whole year. Number of its member in case of public company reduced below 7, private reduced below 2, unable to pay its debts. Court is of opinion that it is just and equitable to wind up. Company has made default in filing with ROC, its balance sheet, P&L or annual returns for 5 consecutive years. Company has acted against the interest of sovereignty integrity of India. Court is of opinion that company should be wound up under circumstances specified in 424. Who can file petition for winding up? Application for winding up has to be made by way of petition to the court, that is your High Court. It can be filed by company or creditors, including contingent of prospective creditors, any contributories or all or any of the parties specified ABC, whether together or separately, or by ROC, any person authorized by CG or state government in case of inspection or inquiry. Remember this. These sections are old sections. Now next one is voluntary winding up. Why will company wound up voluntarily? Their reasons are given. When period fixed for duration of company has been completed, when business of the company has been done, the company do not want to do any further business, it can go for voluntary winding up of the company by passing the resolution in the general meeting. If company passes special resolution, that company be wound up voluntarily. This company may be wound up voluntarily on expiry of term fixed duration of the company or on occurrence of any event provided in the articles. In these two cases only ordinary resolution may be passed in the general meeting. But apart from these two cases, special resolution is compulsory in the general meeting. We have to explain the facts to our members and creditors why the company is going into winding up. The resolution has to be advertised within 14 days in the official gazette and also in some newspaper circulating in the registered office of the company. Voluntary winding up, please remember this is very important. Voluntary winding up commences from the date of passing of the resolution, whereas Compulsory winding up commences from the date when petition is filed. Okay, please remember this. Effect of voluntary winding up is that company ceases to carry on its business except so far as may be required for beneficial winding up. Corporate status and powers of company, however, continue until it is dissolved. Kinds of voluntary winding up, two kinds: members voluntary winding up and creditors voluntary winding up. Why will members voluntary wind up? Company may be solvent, able to fully pay off the liabilities. Over here, creditors' consent is not required because they will get their money. Creditors are concerned only for their money and nothing else. Okay, but members now don't want to continue with the company, right? Yes, in compulsory winding up, company only files a petition because the company can only file petition. Okay. When company is solvent as unable to pay the liabilities in full, it need not consult the creditors. Its directors, when they are more than two, majority of directors at the board meeting will make a declaration of solvency verified by the affidavit stating that they have made full inquiry into affairs of the company and that having done so, they have formed an opinion that company has no debts or that it will be able to pay off its debt in full within such period not exceeding 3 years from commencement of the winding up. This declaration is compulsory. If this declaration is not there, then it will be termed as a creditor's voluntary winding up. Over here, creditors need to be engaged. Okay. Powers of court to intervene. Generally, court do not intervene in the voluntary winding up, but these are the few cases where court will interfere in voluntary winding up of the company. To appoint the official liquidator or any other person as liquidator where no liquidator is acting. To remove liquidator and appoint official liquidator or any other person as liquidator on justifiable cause being shown. To determine remunerations of liquidator when official liquidator is appointed. To amend, vary, confirm or set aside the arrangement entered into between company and its creditors on appeal being made by any creditor or contributory within 3 weeks of completion of the arrangement. On application of liquidator or contributory or a creditor to determine any question arising out of winding up. To exercise as respect enforcing calls, staying of suits, other legal proceedings, all or any other powers which court might exercise if company were being wound up. To order public examination of any person connected with promotion or formation of the company. Commencement of winding up is very important as discussed earlier. Winding up of the company by court is deemed to be commenced when there is a presentation of petition with the High Court. But when there is a voluntary winding up, it is deemed to be commenced when the resolution is passed in the general meeting. Please remember this quote.